I'm holding in my hand a copy of the pattern jury instructions. Come join me. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial attorney. Today I want to read to you the exact section of the law that typically is given to the jury at the end of a medical malpractice trial in New York. Now, there are many variations, and the judge may make variations, but here's typically what is given. And it gives a legal definition, so pay attention. It's very important. Malpractice is professional negligence, and medical malpractice is the negligence of a doctor. Now, negligence is the failure to use reasonable care under the circumstances, doing something that a reasonably prudent doctor would not do under the circumstances, or failing to do something that a reasonably prudent doctor would do under the circumstances. It is a deviation or departure from accepted practice. Now, the instruction continues. A doctor who renders medical service to a patient is obligated to have that reasonable degree of knowledge and skill that's expected of an average doctor or an average specialist who performs or provides that particular treatment in the medical community in which the doctor practices. The doctor must also comply with the minimum standards of care. Now, the law recognizes that there are differences in the abilities of doctors, just as there are differences in the abilities of people engaged in other activities. To practice medicine, now this is important, pay attention. To practice medicine, a doctor is not required to have the extraordinary knowledge and ability that belongs to a few doctors of exceptional ability. That's an important point. However, every doctor is required to keep reasonably informed of new developments in the field and to practice medicine in accordance with approved methods and means of treatment in general use. A doctor must also use his or her best judgment and whatever superior knowledge and skill he possesses, even if the knowledge and skill exceeds that possessed by the average doctor or average specialist in the medical community where the doctor practices. Now, here it continues. By undertaking to perform a medical service, a doctor does not guarantee a good result. So this is the law that the judge actually tells the jury. He's telling them, you are not guaranteed a particular result. And that's an important point. It's something that's hammered home to them by the defense attorney. The fact that there was a bad result to the patient by itself does not make the doctor liable. Think about that. If you suffer a bad outcome or a bad complication following a procedure or treatment, again, does not necessarily mean that there's wrongdoing here. It continues on. The doctor is liable only if he was negligent. Whether the doctor was negligent is to be decided on the basis of the facts and conditions existing at the time of the claimed negligence. A doctor is not liable for an error of judgment if he does what he decides is best after careful evaluation, if it is a judgment that a reasonably prudent doctor could have made under the circumstances. In other words, a doctor is not liable for malpractice if he or she chooses one of two or more medically acceptable courses of action. Now, if those medical courses of action deviate from good and accepted care, then we can show that there is negligence. Now, if the doctor is negligent, that is, lacks the skill of knowledge required in providing a medical service, or fails to use reasonable care in providing the service, or fails to exercise his or her best judgment, and such failure is a substantial factor in causing harm to the patient, then the doctor is responsible for the injury or harm caused. Now, there are a lot of variations and legal nuances associated with every single instruction like this, and it's critical for you to understand that there's so many different instructions that apply at the end of the case. So why do I even tell you about this, and why do I explain to you some of the things that are in the pattern jury instructions? Well, I'm just giving you an insight and an understanding into what occurs, especially in the trial and toward the end of the trial. And chances are you're watching this, you have questions and concerns about your particular matter. So what I want you to do is pick up the phone and call me. I answer legal questions like yours every single day. You can reach me at 516-487-8207 or by email at lawmed10@yahoo.com. I'm Gerry Oginski here in New York. Thanks for watching.